Hi everyone, I'm Siri Mårtensson. I'm a lawyer and I work at Delphi Law firm. I'm specialized in IT law and I've been asked to give you a brief presentation of the Oracle versus Google case. And I will also give you a brief introduction to the legal protection that you can receive for your APIs. This presentation will not include any technical details, so I hope you are fine with that. So this is the case. I don't know, many of you probably have heard about the case. It's the case between Google and Oracle, where Google used a part of the Java API and put it into Android. And Oracle saw this as an infringement of their API. Just to give you a brief background of the case, Oracle purchased Sun Microsystems in 2010, so they did not develop the Java API in question, but they purchased the Sun Microsystem and thereby acquired the rights. And in August, they sued Google, and they claimed that Google had used the Java API without the license permits from Oracle. And they claimed that it was first patent infringement and second that it was a copyright infringement. In 2012, the first court found that first of all, they found that the patents were not infringed. The patent scope was not infringed. Secondly, they found that the API was not subject for copyright protection, and that the API was a method or a function, and it couldn't receive any copyright protection. So this was a major setback for Oracle because they didn't have any success. But they did, however, appeal to the appeals court, and the appeals court found that a structure and a sequence and an organization of an API is actually copyrightable. And by saying this, they said that this API does actually have protection, and then they remanded the case back to the first court in order to have a full assessment of the case. And as you can see, this has going on for quite a while. They started in 2010, and now in May 2016, we got the second ruling from the district court. And they found that the Java API was not infringed, since Google's use of the API was covered by fair use exception. So Oracle had a setback also here. So to summarize the claims or the positions of the parties, Oracle's claim was based on that they believed that Google developed parts of Android by illegally copying core Java technology and just put it directly into Android. And they said that they copied 11,500 lines of code. And this is actually undisputed, because they did this. They actually put these lines of codes into Android. And they didn't pay a license for it. However, on Google's position, they argued that the Java language has always been free and open to use. And when Java was owned by Sun, the former CEO actually said that and accepted the use of the APIs. And they also said that this part of the code is just declaring code. And it's just a very, very small part of the code. 11,500 lines of code might seem like a lot, but in this context, it was actually just a tiny, tiny part of the code, since it was 15 million lines of codes in total. One example that was presented to the jury during the case was this, that is a declaring code. And it's just merely giving a function and a shortcut. To give you a brief overview of the legal questions at hand in this case, I will present this from a Swedish perspective. Since I'm a Swedish lawyer, I can only advise in Swedish law, but this will of course have effect also. This case will have effect also in Sweden, but I will give you the legal basis from a Swedish perspective, and then I will sum up my view. So if we start with the first part of the case where Oracle claimed that it was a patent infringement, they had 2 method patents, and method patents is actually quite rare in Sweden, and I would say that patents for software at all is very, very rare. In the US, it's very much easier to receive a patent for software. In Sweden, this are the requirements that needs to be fulfilled in order to receive a patent. It needs to be useful. It needs to have a technical character and a technical effect. It must be reproducible, meaning that it must have the same technical effect each time. If we take an example with a mathematic algorithm, the mathematic algorithm as such is not patentable. But if you find a specific technical effect that the algorithm can be used for, then you can have a patent for the algorithm. The second requirement is that it needs to be new. Cannot be known, and it needs to have an inventive step. So it needs to be substantially different from what is already known. And my recommendation is, if you think that you have a product or a software or any invention that you would like to patent, I always advise you to contact a patent lawyer and a patent engineer in order to decide which part that can be subject for patent. So if we go to the core of the case, which actually regarded copyright protection, we can start with what can be copyrighted by copyright protection. Copyright can be received for literary and artistic works, and that means productions in speaks and in writing. Computer program is a perfect example of a product that can be a subject for copyright. The source code is a literary work and is thereby covered by copyright. Databases can also be covered by copyright in some cases. Libraries and also APIs, as we have now seen. And then there's a lot of examples on other things that can be subject for copyright, but I will not go into that now. What is important for you to know is that it's always a format that is protected. An ID or a function or a method can never be subject for copyright. You need to write something down. It needs to be physical. And that was the core question in the first case, that the court found that this is a function, a method, and that is not subject for copyright. So it needs to be an expression. The other requirements that needs to be fulfilled in order to receive protection is that it needs to be original. It needs to have a distinctive character. And you say it said that it needs to be a result of an individual creativity. And to try to give you an example, you need to do something more than just stating the obvious. If I would say, and just saying that my name is Siri and I like ice cream and football, that would not have any creativity. That would not have any originality, and I would not have protection for that. And this right is not possible to register in any way. It arises automatically at the moment where I'm writing the code down. And it arises at the person who is writing the code, which is important to have in mind if you're a company, because the copyright arises with the person writing the code, but then this right is handed over to the company if it's an employed. But if you contract, for example, an engineer outside your company developing your code, then you need to have an agreement saying that you as a company actually requires the rights to the code. Otherwise, the rights stays with the consultants or the engineer. So that is very important. A question that I often received is the use of the CE mark. Does anyone know if it has any effect? It doesn't have any legal effect, at least not in Sweden. This is mostly used in countries like the US, and it can be used, of course, like stating that you claim the rights to this work, but it doesn't have any legal effect. By just stating a copyright mark doesn't mean that you, per definition, have a copyright. Okay. So, what does the copyright protection imply? There are two parts of copyright. The first one is the economic right, and the second one is the moral right. It is the economic part that is interesting here, because this is the exclusivity to decide how your work is presented and distributed and displayed. And it sets out that you always have the right to get compensation if your work is used in any way. So this is the basis for damages. And this is what Oracle claims, that they used the API without permission and without paying, and thereby they claim damages. The second part is the moral right, and that is more for authors and a right to be named. The term of protection is 70 years. In some cases it's 50 years, but 70 years from the death of the author. And that can be a bit difficult if you're a company to decide when does the copyright cease. So, if we go further into the exceptions, there are some exceptions to copyright. That is to say, when a copyrighted work is permitted to use without paying. And in Sweden we have these exceptions. It's private use, quotations, education purposes, orphan works, and making of temporary copies in order to make transmissions possible. However, it's explicitly said that computer programs is accepted from this exception. In the US, we have a doctrine called the Fair Use Doctrine, which is used in this case. And the principle, it's quite like the one that we have in Sweden. It's just that it's a bit broader. It's more of a doctrine, and it's gives more. It's more open for interpretation, I would say. But you can see here it's the same purposes: reproduction and copies, for purposes that's criticism, commenting, news reporting, teaching, scholarships, and research. And I don't actually see the definition here that was used in the Google case. But the court found that the Google's use of the Oracle or the Java API was under the fair use doctrine, since it was small and justified, they said, and it was in order to enable interaction between programs, and they said that it was no market harm, because it was the code had already been made available previously by Sun through the open source of OpenJDK. So the code was already open source in some part, and that was also one thing that made, I believe at least, that made the court that the court came to this decision. So, to just sum up with my own reflections regarding this case, it is not actually certain that the result would be the same in Sweden, since we're not using the same fair use doctrine. We have, I would say, a more limited scope for exceptions. But it hasn't been tried, so this is just my own speculations. But this verdict will have a huge impact also on the business in Sweden and in Europe, because many of you are doing business globally, not only here in Sweden or in the EU. And to end up having just a case, just to have a lawsuit from a bigger company saying that you are infringing our API or our rights, can take a very long time and take a lot of money and time and effort spent during this case. So even if you would end up being right in the end, and that you had the right to use a code, or it's still a big risk. One reflection that I have is that it's dangerous if the copyright protection is too wide. If you are able to copyright also facts and functions and methods. So I think it's perfectly right that the court came to this decision. But on the other hand, it's very important that the rights holders' rights are maintained, so that you can protect the values of your API. So my recommendations is to have a strategy for your protection. Try to sit down and think of what protections do we have with our API or our source code or our platforms. And if you wish to patent something, always consult with an engineer or a patent lawyer. Think about, where do you make your money? Is it the licenses to the actual API, or is it the license that you give to using the platform or the actual product in the end? And implement accurate license agreements after you've done your strategy and thought out where do we make the money. Implement accurate license agreements. And if you're developing code, always document the development. If you're using subcontractors or employees, keep track of your development, and make sure that you can prove that you are the developer and the rightful right holder in the end. So, yes, that was me.